Thank you very much to everyone for sticking with us today. We're going to close today's event with a conversation on criminal justice. And I'm thrilled to be on stage with two experts who are well-versed in a number of matters pertaining to the criminal justice system. The first to my left is Professor Paul Heaton, who is the academic director at the Quattrone Center for the Fair Administration of Justice, housed here at the University of Pennsylvania. Professor Heaton is one of the leading economists looking at the criminal justice system, and he approaches it from a very data-driven vantage point which looks at the crime, courts, legal policy, and applies an interdisciplinary systems approach to figure out the ways in which the criminal justice system might be improved. Also joining me on stage is Professor David Rudofsky, who is a senior fellow at the University of Pennsylvania and also an expert in matters pertaining to criminal justice and civil rights litigation, who has a wealth of experience litigating matters both as a criminal defender himself and then since more pertaining to the criminal justice system at a systemic level. I want to begin by just quoting a few statistics that were just in a Philadelphia.com story just 2 days ago that I think will provide a useful context for some of the issues that we're going to discuss this afternoon. And frankly, I think all three of them are pretty shocking. The first is that in Philadelphia, there are 8,000 people currently incarcerated, which is actually a decrease from 2009 when it was 10,000 people. Of the 10 largest cities in the country, Philadelphia incarcerates the highest percentage of its population. Of those people currently incarcerated, a huge percentage of them are people incarcerated in pretrial settings. Just this year, there have been 6 inmates who've died in detention, each of whom was held pre-trial on a misdemeanor charge with a bail set at $500. There are 300 people being held right now pre-trial, each of whom has been held for over 16 months, and none of whom is being held on a murder charge, so meaning for each of them, bail has been administered voluntarily. So I'd like to begin the conversation asking you, Professor Heaton, to sort of set the stage with bail and sort of making sense of the way our systems of bail works, what the objectives of bail are, and the reasons that we end up holding people and how we hold people in pretrial settings.
Great. Thanks, Jacob. And, I think it's fitting that we start this conversation with bail in a symposium that thinks about how money defines our rights, because, this is a setting where it's literally the case that, I get arrested. If I have enough money, I pay the money and I get to exercise my right to liberty. And if I don't have enough money and if I can't make bail, then I remain incarcerated. So, this is a portion of our legal system where we're literally exchanging money for freedom. Now, in theory, bail is supposed to serve 2 purposes. It's supposed to ensure that individuals reappear and show up for trial, and it's also supposed to protect the community. Now, I think there's a lot of questions about whether, altering the amount of cash bail, which is the predominant way in which we kind of fine-tune bail in the United States, is really sufficient or adequate to serve these purposes. Certainly, if we look at academic research, I think there's strong arguments to suggest that latter purpose of serving the community isn't very well served, if it's served at all, by cash bail. And of course, there's lots of questions which we can explore about the fairness of a system which essentially causes people who are lower income to face longer periods of incarceration when they haven't actually been convicted of any offenses.
So when we think, or at least when I think about bail, at least prior to law school, I think the way in which it's most commonly popularized is through the idea of bounty hunters. We have sort of sexy visions of people out on bail, skipping bail, and being hunted down. In practice, is that how cash bail is working, Professor Rudofsky?
Well, it's working. I think, as Paul said, it's interesting. 60 years ago, in a case in the United States Supreme Court, and you have to watch out for rhetoric as opposed to reality, the court, in addressing a case in which a defendant was not able to perfect an appeal because he didn't have the money to buy a transcript from the trial, the court said, and I quote, "There can be no equal justice when the kind of a trial a man gets depends on the amount of money he has." Well, of course, that's the rhetoric, but we don't really follow that often in the criminal justice system. And as Paul says, bail is a good example. And in fact, in Pennsylvania, it is true in some states, and certainly under the federal government, bail can be used to prevent dangerous people, right? We use it as a preventive measure, right? People we think are dangerous because they've been arrested and charged with a particular crime, not yet tried. We can use that as a trigger to prevent them from being released before they're actually tried on the case. Federal Bail Reform Act did that about 25 years ago. Pennsylvania, actually, the only reason for bail under our Constitution is to ensure that someone appears at trial. And of course, the way we run it, it's completely irrational, right? When we think about that point, if you have the money, even on a very serious charge, and even though there may be indications that there may be flight, you can get that very high bail, you'll make that bail 10% and you'll be free. As you mentioned in those statistics, we use bail in a way that inevitably, even if we are parsing it correctly, even if we're looking at those cases correctly and thinking we're calibrating the amount of bail correctly to the offense that's charged, to the prior record, and to the likelihood of appearance, what we're doing inevitably is keeping people in who nobody thinks even should be in that system, right? So when you have those 300 or 400 people there, right, on $500 bail or less, everybody expects them to get out. But with the huge numbers that we have, inevitably, you're going to find people who don't have the $50 or $100 to get out. So it's certainly irrational on that basis. And the fact is, it's used. There's kind of a pretext going on. Everybody says, well, we need high bail or cash bail to ensure appearance at trial. That's not what they're really concerned with. What they're really doing is saying, I think this person is too dangerous to get out, right? And the factors that they're using, I mean, that may be a legitimate reason. People can debate whether that's a legitimate reason, whether an arrest should trigger deprivation of liberty without anything else based on the seriousness of the charge. But that's really not what's going on. We could debate that issue, but that's not what's going on. We're using, in a sense, the pretext. We want to ensure that you're going to appear at trial. Most people don't leave the city. Most people have no means of fleeing. They may not come, but it's not because, right, of the amount of bail. We use that really as a way of thinking some people are too dangerous. And it is so broadly applied that, you know, within a large number of cases, we make very serious mistakes. And let me make one other point about that, which I'm sure we'll get to. All of this is related. When you think about the person who's held in bail, right, in jail and bail, if small amounts or large amounts, we've seen many cases on the defense side. Prosecutors have seen them as well. Think of a situation where you're charged with a misdemeanor. You've got bail that you can't depose. You don't have the money. Basically, your lawyer says you've got two choices. You can go to trial if you want. That's going to take 90 days. The prosecutor is offering, if you plead today, we'll give you time in. Right? Spend a weekend, plead guilty. No investigation has been done in the case. We don't even know what the prosecution's case may look like. Many rational people, and I've had those clients, right, have said, I'm not guilty, I'll take the deal, right? And so we have this kind of enormous plea mill that goes on, and some of it kind of literally generated and charged by the bail factor.
So to put a finer point, if I can, on how this plays out, I mean, I know you've done research in Houston about the way that bail practices are used. Would you walk us through the research, what it's shown as you
So I mean, you'll have to forgive me. I'm a little bit of a data guy, as Jacob said, and so you know, let me, and you know, this may be a little bit. Hopefully, you can see this okay, but let me just show you two easy slides that I think kind of illustrate the problem here. And for those who can't read it all, I'll kind of walk you through here. So this is actually data that we've collected from the Quattrone Center. Underlying this picture is about over 70,000 individual bail determinations in misdemeanor cases in Harris County. So this is the county which includes Houston, Texas. And, you know, we probably think if we were to draw this picture for most large cities in the U.S., we'd see a similar pattern. And so each dot here represents all the defendants who come from a particular zip code. And if you look on the horizontal axis, I'm orienting them based upon how wealthy the zip code is. So what's the average income, household income? And then on the vertical axis, what I'm plotting is what fraction of people who are arrested actually get released pre-trial. So what fraction are able to make their bail? And when you look at the pattern, you see quite clearly that there's a very, very strong relationship between how much money you have and whether you're going to be released. Those who are in the wealthiest zip codes over on the right have about 4 in 5 of them will get pretrial release. For the poorest zip codes, it's closer to 1 in 3. And as David said, this has a lot of consequences for what flows after. We know that there's a strong relationship between pretrial detention and your likelihood of pleading guilty. And of course, when you plead guilty, that builds a criminal record. And if you come through again, your bail is higher, and this process can perpetuate itself. Now, some of you may be saying, well, hey, sure, it does seem like that wealthy people are being released at much higher rates, but maybe it's just because they're committing less serious crimes. Well, no, actually, if you look at the data, there's absolutely no relationship between the seriousness of your offense and the wealth in your zip code. So in other words, poorer people are committing the same types of offenses as everyone else, but they're just sitting in jail while people who have the money make bail and get out.
So, given what seem to be pretty manifest problems with the way that this situation, or excuse me, with the way that bail operates, why are we still using it? I mean, is there a way in which cash bail can be equitably administered and it's just a lack of alternatives, or is there some other reason why we still rely heavily on a problem that seems to be so clearly inequitable and inefficient?
Yeah, as we all know, the legal system changes very slowly, right? Even when you know there are problems. But there are some signs in the last couple of years of maybe some ways out of this problem. A number of cities have started to do some reforms on bail. Philadelphia is looking at that as well. We'll see if it does it, because as you say, Philadelphia's got the highest incarceration rate of 10 major cities in terms of its jails, put aside the state of Pennsylvania. New York, for example, has recently moved, and think about these numbers. Philadelphia's got 8,000 people in its jail. We've got a population in Philadelphia of 1.5 or 6 million people, right? 8,000 inmates in the local jail. New York City, with a population 5 times as many as Philadelphia, over 8 million people. In Rikers Island, there are currently about 10,000 inmates. Almost the same number, right? So we are incarcerating at 5 times the rate of New York City. And New York City is no great model either. I mean, they've got its own problems. But even with that, what they've moved to is a system of, they're starting to move now on minor charges, simply not requiring cash bail. I mean, why require the $50 or $100 or $150? That's not why people appear or don't appear at trial in the first place. So cut out those, those very minor cases, the misdemeanor cases and so on, and simply don't require any cash bail. Release the person unless there's some very, very good reason you have that person, right, should be maintained in custody. Beyond that, there are a lot of other methods of ensuring, right, that somebody appears at trial and perhaps doesn't commit new crimes during that time. There's day reporting to probation and parole. There's electronic monitoring. We've got a lot of capabilities of making sure that people who are awaiting trial, right, actually get there and appear. And again, it's very, very few people who disappear, and it's usually the rich who disappear, not the poor people who disappear in terms of coming to trial. So there are a number of ways of doing that. There are also some interesting experiments in some cities using, instead of kind of like the matrix we use in Philadelphia, where we chart bail by looking at the seriousness of the offense and your prior record, right? We've got this little chart, and based on that, it comes out to a certain number, anytime you do it on that kind of actuarial basis, you're going to make a lot of mistakes as to individuals. A number of jurisdictions, with the help of some foundations, are coming up with some evidence-based approaches to bail. What really should we be thinking about in terms of whether someone will appear or not? It may not be the seriousness of the charge. It may not be their prior record. We've got to be careful with that because sometimes you can build in economic or racial factors that aren't fair. But in jurisdictions where they've done that, they've been able to reduce the jail population. So there are a number, and I see people in the room who have been working on these kind of issues. There are a number of ways of thinking about that and actually reducing the population pretty drastically without any endangering of public safety. The last point is, obviously, as well, we need more resources to try those cases quickly. A lot of the reason we have, as you said, such a high jail population, particularly in Philadelphia, is that many people wait months and sometimes years to get to trial. And I'm not pointing fingers. That's sometimes at judges who aren't sitting long enough. That's sometimes at defense lawyers who aren't ready. It's sometimes at prosecutors who can't get their case together. There are a lot of problems sometimes in getting cases to trial. But oftentimes what we see in places where there are high populations, it's because of that fact.
I want to quickly follow up on 2 points that you had raised. The first was you had mentioned New York has gone to a system in which there are certain categories of offenses and people that they're just not holding on bail. Have they seen different numbers as far as who's returning to court, or has it largely been as effective or any more effective than what happens with cash bail systems?
Yeah, this is a new program there. I don't think we have much data. Emily is here from New York. She's been working on that. Maybe she can help us on that point. She's been working very closely on the bail issue. But I think it may be too early to know what impact it has. Okay.
I mean, as a general matter, you know, there have been over the years a number of efforts to run various experiments where we liberalize pretrial release. And, you know, I think the general message of the social science and academic research suggests you can often liberalize a fair bit without really impairing appearance rates that much. And I think that provides some of the basis for some of these experiments.
So given the fact that experiments have played out in that fashion in which the results haven't been markedly different, and looking at data like the data that you've collected, how do you make use of information like this to bring about change to our bail practices? Either as a litigator using information like this, or from your end, Professor Heaton, as someone who's looking at it from an economic standpoint, either working with people who might create changes within the litigation context or from a policy perspective?
Well, yeah, I mean, I think you've hit on the two main approaches, right? Sometimes these changes can come from forward-thinking policymakers. You know, we can develop, you know, new programs as these bail funds provide an example. We can, work through the courts or legislators to foster change. But in some cases, you know, litigation is the answer. But, you know, this is you know much more than me on this, but I think this is a tough area to litigate in many ways. And so, I think reaching the policymakers and providing the information and the kind of strong empirical evidence that suggests, hey, this is something you can do, and it's going to lower your costs, and it's going to potentially improve equity quite a bit. You know, part of it is just getting that message out there and producing the evidence and giving it to policymakers.
Yeah, this is. Yeah, I mean, there ought to be, you know, and some places have it, almost an automatic review, right? So if someone's in on bail, which requires them to post 500 or less or 1,000 or less, which most people can eventually get together, after 3 days they don't have it, right? That case ought to be brought back, and some other means to find ways of getting that person out. Best not get them in the first place. I mean, that's the expensive part. That disrupts lives. You lose jobs just in the 3 or 4 days, but at least build in that review. On the question of litigation, you would think, boy, this is the easiest one in equal protection, right? I mean, what could be a better equal protection argument than, right, the rich person gets out and the poor person doesn't, right? It could be the same charges, it could be the same background, it could be the same risk of flight, and in fact, it could even be more serious for the rich person. They're getting out, the poor person is not. Courts have not been very open to this litigation. It's hard. There are so many cases. There are so many factors. The U.S. Supreme Court a number of years ago upheld the notion of preventive detention, right, under the Federal Bail Reform Act, where they said it's permissible, given some procedural safeguards, to hold someone simply because of the seriousness of the charge and the notion that they will reoffend, assuming they offended in the first place, right, on the charge. So it's not easy. There is some litigation around the country in some jurisdictions that really don't pay attention to individual cases and just have this kind of automatic system. But I think Paul is right. I think, and it's part of this whole new conversation about criminal justice, right? So that, in the last few years, what's remarkable, at least in the rhetoric, again, I haven't seen a whole lot of results, the right and the left kind of joining on this question of over-incarceration and mass incarceration and overuse of the criminal justice system. So I think there are some possibilities. New Mayor Kenney in Philadelphia talks about bail all the time and the unfairness of it. Philadelphia is currently in the process of seeking a MacArthur Foundation grant. MacArthur Foundation is offering a significant money, millions of dollars, to cities to come up with plans to drastically reduce their jail population. Philadelphia is looking at that, so there may be something that happens here over the next couple of years.
So you had mentioned there's been alternatives that have been implemented in some jurisdictions and data that obviously shows the problems with the systems there are now. Are there interests that sort of advocate for maintaining cash bail? Is there a reason why it still is as prevalent as it is?
Yep. It's always right, when you talk about reducing incarceration, you have correctional officer unions, right, who fight it because they lose their jobs if you close a jail or a prison. I think in this area, not so much in Philadelphia because we don't have too much impact of bail bondsmen, but in some jurisdictions, bail bondsmen who make a living, right, on posting bail and taking part of that money as a fee resist this kind of reform. So you've got some economic interest, that I think are fighting against it, but I think more it's kind of the thing that I think prevents the reform, or has to now, is the notion that, an arrest really does indicate something. If it's serious enough, we want to hold that person. And a judge who's thinking, the only thing that can happen is bad for me. If nothing happens, no one will know I made the right choice. If I release somebody and they commit another crime, I'm on the hook, right? And you see it all the time, right? So someone shoots somebody, an officer, and all of a sudden we're looking, who was the judge that let this person out on bail? So the whole system is built to disincentivize, right, taking the kind of chances we ought to be taking.
I mean, I completely agree with, that assessment. I think one additional obstacle that you see is, as David mentioned, I think one of the areas of promise with respect to bail reform is we are getting some better technologies, electronic monitoring and other things which, potentially provide some better and more finely tunable tools, particularly with respect to addressing the issue of risk to the community. I think there have been some examples, and this sort of problem arises again and again in the criminal justice system where we begin experimenting with these tools. There's some high-profile case where the tool goes wrong. Hey, the person on GPS monitoring during pretrial release, we commit some additional crime and isn't stopped. And as a result, we kind of decide there's a public outcry, and we say, oh, that tool must not work. Let's go back to cash bail, the tool that works even less well. And so I think, trying to overcome that reactionary posture that often occurs in the public with respect to criminal justice matters is certainly going to be important to advancing reform in this area.
So you mentioned a couple technologies that might be available to achieve some of the same goals. Can you expand on what technologies there are, reasons to think they may be effective alternatives, and how they would be, how a jurisdiction would be able to make use of them?
Yeah, I mean, certainly you can think about things like technologies that facilitate GPS monitoring, that electronic home monitoring, that facilitate more frequent contacts between someone who's on pretrial release and a correctional authority. So if you think of Kentucky, which instituted a few years ago a fairly substantial bail reform and substantially increased the fraction of defendants who were able to have pretrial release, their solution was a combination of, having more contacts, using some of these electronic means. They also actually had, I think, kind of an innovative approach to cash bail that involved gradually reducing the amount of bail over time. So essentially, if you weren't able to make bail initially, you got credit for each day served so that your bail amount lessened over time. I think we still need more evidence on how that sort of an approach works, but definitely innovative.
Well, one of the things that you had referenced, Professor Rudofsky, was evidence-based practices. Can you expand on what you mean by that?
Yeah, I mean, these are, this is an area that's very contentious, both with respect to bail, to sentencing, to parole decisions, in which we're trying to predict something, right? So bail, we're trying to predict whether somebody's going to appear at trial or they're going to be dangerous if we release them. Sentencing, we're factoring in how much time somebody should spend so they will be deterred or other people will be deterred in the future. Parole decisions, is the person ready for release or not? All entirely predictive, right? All entirely predictive. And the question is whether there are factors and metrics that can better predict, right? More reliably predict. Those very difficult, and as I say, sometimes very dangerous, because oftentimes you can bring in socioeconomic issues or racial factors, right? Which might seem to indicate, right, on a large-scale basis, those factors, and that may not be fair. But at least in the last 5 or 10 years, in a number of jurisdictions where it's been used on bail, we've seen a reduction in the number of inmates. On parole, in some jurisdictions, we see more people paroled, right, using the new metrics. But it's, I don't think the jury's in on that one. I mean, I think we should keep looking at that. But this whole basis of trying to predict, right, based on a whole set of factors, kind of actuarial, whether this individual or that individual will do well on parole, right, could do with a shorter sentence, pretty hard.
So continuing with this idea, Professor Heaton, is there reason to think that we could trust data to objectively identify who might be the most risky people, or is turning to a practice such as evidence-based practicing, as Professor Rudofsky laid it out, risking that we're going to just create some of the same problems but sort of recast it as the product of objective data?
Yeah, I mean, it's, I share your ambivalence, I think, David, about these new technologies, because I do think there's a lot more data and, the actuarial science, and, we talk about big data, and there are some opportunities, but, I think there's also this kind of, normative question we really need to ask ourselves, which is, you can argue that in some sense those types of actuarial modeling or efforts to, potentially incarcerate people based upon their future activities. And, I think there's some real, questions about, is that, do we want to do that? And what are the limits to that? And, I understand that the way the bail system is set up now, in some sense, whether we explicitly acknowledge that, the fact that we take into account danger to the community means that we're going to do some of those things. But, I think we want to be careful about moving to the minority report world, right?
Right. So, to change the topic quickly, to another mechanism within the criminal justice system in which money really plays out in quite profound ways, is systems of defense. And each of you has approached this question at a systemic level. Professor Heaton from the more data-driven perspective, and Professor Rudofsky as a litigation matter. Starting with you, Professor Heaton, I know you had done a study in Philadelphia about the way murder defendants or homicide defendants receive defense counsel in Philadelphia that was published in 2012. Can you explain what it was that you had found about the ways in which homicide defendants are represented in Philadelphia?
Yeah, sure. So again, I think indigent defense is a very interesting area where you see resources and financial factors really coming into play. And, I think to understand the different ways, first I think we need to go back to David's point that, resourcing is a big issue throughout the criminal justice system, but perhaps nowhere more so than if you think about the resources that we devote to indigent defense. And, the vast majority of people who are arrested for serious crimes don't have the money to afford a lawyer, and so they rely on the courts to provide them an attorney. And in Philadelphia, as in most jurisdictions, there are two predominant ways of doing this. We have a defender association, so public defenders, people who are salaried and kind of work full-time on indigent defense, and then private appointed counsel. So these are attorneys who are in their own practice, but they might come in on a one-off basis, and the court brings them in and says, here, represent this client, and we'll pay you some sort of a fee based upon some predetermined fee schedule. So to understand why or what some of the effects of these systems might have, and particularly the financial arrangements, I want you to do a little thought experiment with me. Imagine that we have a line of criminal defendants, they've been arrested and they're coming forward for processing, and imagine that every fifth defendant who came forward in the line, I handed them a coupon, and the coupon said, this coupon is good for 6 years off of your eventual sentence. So that sounds to me like some sort of a bizarre dystopia, but in fact, you could argue that's kind of what we were doing in Philadelphia for many years with respect to murder defendants, and the reason why had to do with our system for providing counsel. So the Defender Association is kind of highly professional, but a small organization that can't handle all the murder cases, and so they would be assigned 1 in 5. And what my research demonstrated, I think fairly conclusively, that as a result of the better representation that public defenders were able to provide, their clients had much better outcomes. So the expected sentence was indeed 6 years shorter for the 3,400 or so murder defendants that we analyzed. Substantially less likely to get life imprisonment, less likely to be found guilty of murder. And there are a number of different structural and other reasons, but I think one of the key contributing factors to this disparity in performance between the public defenders and the appointed private counsel had to do with the fee schedule, how much we pay private attorneys. At the time of our study, in potentially a murder case, as a private appointed attorney, you'd get $1,333 if your case settled before trial. If you went to trial, we'd bump it up to $2,000 and then give you a payment of $400 per day. So if you were to take the ABA's estimate of how much time it takes to adequately prepare in a murder case, that comes out to about $2 per hour. So this is a situation where, as a result of not providing adequate resources, people were, I would argue, not getting the sort of representation that we'd really want for people who, in some cases, literally have their lives on the line.
So your report highlighting these disparities was published in 2012. Is it still the same model we use today?
There have been some improvements, and some of them I think, we can attribute to the work of, David and other litigators who have tried to, use litigation to, prompt some reform in that area. So I don't know if you want to talk about that a little bit.
Well, in Philadelphia, it's still the same model. We're still only giving 1 in 5 cases to the Defender Association, and Ellen Greenlee here, who was the chief defender for 25 years, started the homicide unit about 20 years ago. For particularly this point, the representation was so poor, and ensured that everybody that the defender represented had 2 lawyers in a capital case, one who was mainly focused on the trial stage, guilt or innocence, one who was doing mitigation, investigators, social workers, and lawyers with as much experience as the prosecutors who were assigned to the homicide unit in the DA's office. Everything Paul says is right. The results between those cases And the 80% of the cases that were assigned to lawyers paid, right, the $2 an hour, resulted in some pretty dramatic differences. In a city in which there were a lot of death penalties over the last 20, 25 years, that unit still has not had a single case where the death penalty has been imposed. So a dramatic difference based on the quality of lawyers, and obviously the quality of lawyers is tied somewhat to money. The system has only gotten a little bit better. We actually brought a lawsuit against the court system for its very low payments in homicide cases. They've now raised those payments, but not enough. So lawyers are getting more than the $2,000, they're getting $10,000. It's still a system where it's pretty much pro bono, right? I mean, some lawyers do a very good job. Other lawyers don't, because they simply don't have the resources. And I think we see that repeated and replicated across the country in one way or another. Not necessarily between defender officers and private lawyers who are appointed. That's sometimes how we can measure it. But much more, I think, in just the very, very low funding of indigent services, whether it's provided by defender offices, whether it's provided by assigning private counsel, whether we give a bunch of cases to a lawyer, whatever model jurisdictions adopt for providing defense counsel to those who are indigent, and we're talking about millions of cases a year across the country, notwithstanding the promise of Gideon, right, that we're going to have a lawyer and that lawyer is going to be effective, what we have is a system around the country where we find, because of underfunding, right? I mean, this is, as you can imagine, defense services, when you think about state legislatures, not a very popular budget item. And what we find repeatedly, and this is not just the outlier, we have defender offices around the country where lawyers at any one time are handling hundreds of cases, felony cases, misdemeanor cases, homicide cases, an impossible task, right? Which is why you hear kind of as an adage, the system really is meet, greet, and plead, right? There's no investigation going on. There's no motion practice. There's no lawyering of any kind. It is basically a plea mill, forced in part, right? Not only by people in prison who want to get out, but by simply defender officers and other lawyers simply not having the resources. And that's just, when you look across the country, that is more of the norm than the very good defender officers, and there are some, Philadelphia, Washington, New York, San Francisco, Las Vegas. I mean, there are a lot of very, very good models for how defense services ought to be provided, but those are really the exceptions. I would say 80%, maybe more, of the defender offices and jurisdictions, not because the lawyers don't work hard. We've created kind of an impossible situation for them, and it's literally because of lack of funding, right?
So you mentioned that there's reason to think that Gideon's promise that everyone will be appointed counsel isn't being met. To the extent that that's true systemically, whether it's across a city, a county, as a matter of litigation, are there ways that you can attack that problem?
Yeah, so the one, we've had, you asked about the bail situation where that has not been successful. There have been some successful lawsuits in the last 5 or 10 years and some promise for future developments as well. In about a dozen different states, lawsuits have been brought on behalf either of clients who are facing the situation, right? Defender clients who claim, look, I can't get a fair trial because my lawyer has no time to represent me. And in some cases, filed by defenders themselves who have basically said, and we're involved in a case now in Luzerne County in Pennsylvania, where the chief public defender was our main client, basically filed a complaint in state court saying, because of the lack of funding, we have a situation that's just described, right? I don't have enough lawyers. We have too many cases. We can't do investigation. We can't even interview our clients before hearings. Most of them result in pleas, all that information. And the theory is, and this is where the litigation has gone, the theory is we shouldn't have to wait until after a case is over and try to prove that the effectiveness wasn't there, right, by the lawyer. I mean, we have that remedy, but it's not much of a remedy, right? It means years later, maybe a judge says you're entitled to a new trial if you've been in jail, and you can still bring that claim. The claim here is if we have systemic obstacles to effective representation, that's normally the funding question and number of lawyers, those clients or those lawyers ought to be able to go into court before the trial and say it's predictable. We don't know which case is going to be mishandled, but it's predictable that a significant number of cases are going to be mishandled and get injunctive relief. And so it's a kind of combination of a Sixth Amendment right to counsel, effective counsel, and interestingly, a number of courts have said lawyers have an ethical responsibility not to take cases they can't handle properly. And so very recently, both the Supreme Court of Missouri and the Supreme Court of Florida, in some very interesting opinions in cases involving lawyers who are being sanctioned for not taking cases that were appointed to them over their objection, said the lawyer not only had the right to do that, but had a duty to do that, right? Now, you know, how much is that going to change? It's very hard to do it jurisdiction by jurisdiction. Pennsylvania's got 60 counties. We don't have state funding. So we need a lawsuit like that in 59 of the 60 counties, not Philadelphia. We do pretty well here. That's not so easy. On the other hand, we're getting some support now. The Department of Justice, the Federal Department of Justice, has filed amicus briefs and statements of interest in a number of these cases, including the Luzerne County case, which is now in the Pennsylvania Supreme Court. They came in and said, that's correct. If they can prove, right, these systemic faults, then they ought to be able to force the county or the state to provide more funding. So there is, you know, I think a theory that works. I think we've seen some success in a few cases. New York State, for example, just settled the case and agreed to provide much more funding for a number of counties in New York State. But it's when you think about the breadth of the system and the number of jurisdictions you'd have to litigate in, it's a little daunting to think that we're going to change it simply by litigation.
So I know we're pushing up on time, but I want to ask each of you a final question. So in light of the context in which bail operates, in which defense counsel operates, you know, we would like to think of the criminal justice system as one that reaches the ultimate conclusion of truth. Do you feel, given these practices, the criminal justice system operates in such a way that, you know, our ideals of truth, identifying people who, you know, perhaps merit punishment, are being achieved? Or the principles that are guiding our criminal justice system, have we departed from those ideals to a point where it might not even be fair to call it a criminal justice system anymore?
You take that one, Paul.
Yeah, no, I mean, I think that's a difficult question. I guess, you know, I probably wouldn't be here working in the Quattrone Center if I didn't think that there were opportunities for improvement, in some cases significant opportunities. And I think one of the ways that we can foster improvement is really beginning to think about this as you know, David has in his litigation, as a system, right? And instead of thinking about, in this individual case, what's going on, let's think about how all the pieces fit together. And I think what we see is that as we look at a system, it's become one that, you know, in some cases a little bit like a factory, and it's almost like we're producing these cases as widgets and trying to get them through as efficiently as possible. And I think we can cite many examples where that sort of an approach comes at the expense of fairness and justice in various ways.
Yeah, I think that's right. I think there are two things going on. I think, and we've learned a huge amount from the DNA revolution. I mean, even putting aside these systemic faults, right, in the system, money, bail, lawyers, resources. What we've learned from the DNA exonerations in cases that looked like they were overwhelmingly good cases for prosecutors and people were guilty because there were confessions and there was eyewitness testimony and there were jailhouse informants and there was forensic evidence. Turned out in a lot of cases with all that, people were totally innocent. That fortunately has led, and the Quattrone Center is working on a lot of that, to kind of new practices, right? How do we ensure against false confessions, right? People who are innocent who are confessing falsely. How do we at least improve eyewitness identification procedures, right? So we avoid suggestiveness by the police and the problem then of testimony at trial. How do we deal with forensics, which is a huge issue, right? A lot of labs are producing terrible results, sometimes because of little corruption in the labs, sometimes because they're using scientific, I'll use that in quotes, scientific methods which are junk science, right? Bite mark evidence, hair analysis, which we now know means nothing in a lot of cases. And so we're starting, I think, to see some progress there to make the system fairer. But But even with that, even if you can make those differences, which I think we will continue to strive to, if you've got the kind of structural problems that we have here based on money and resources, I'm not sure how much difference that's going to make. We'll see. We'll keep working on it. We'll see.
Well, on that note, I'd like to thank both of you, and I hope the audience will join me in joining me in this discussion. And thank all of you for staying with us today. I hope you'll join us. There'll be a reception downstairs, so please all come us for food and drinks. Thank you.